in the rain, y'all. Slowing down the rain, but we working. We are working, y'all. Working. Stairs complete. Whitehead Estates, y'all. Coming all together.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. Good evening. It's Pam Esquire, also known as Your Law Intellect, and you are my intellects. Good evening to everyone. I'm back. I had to take a nap after we had a long day in court, literally this morning. We've been watching a trial. If you guys did not watch with us today, we had a good time. We started the trial from the beginning, and I can't even explain this trial right now because we're talking about Whitehead today. But make sure in the morning at 9:15, you guys come check us out and come watch the trial with us. It's about 3.5 hours in the morning we watched, and then we watched about 3 hours in the afternoon. That's why I was tired. Then I started doing some work like I should have been doing earlier. So then I had to go do some errands. Then I had to go take a nap. It's just been a lot. But I said I was going to come back tonight, and I want to be a woman of my word and come back tonight and I have an update for you guys on Whitehead Estates. The video you guys saw was property that is owned by Bishop Lamar Whitehead in Connecticut. He's done several videos showing last summer of different repairs that were being done on the properties. There has been a foreclosure proceeding that was filed that Whitehead has been in since last year. There was also a hearing for the receivership. Just giving you guys a brief summary. We have videos on all of that. The foreclosure part has not been determined. So he is still the owner of the property. But a receiver was granted, which is supposed to go in, take over the rents, and get the building up for repair. However, the finance company who I guess extended the loan to Whitehead filed in March, and we went over that, a motion to dismiss the case. So this is what we're going to discuss today, is that the motion to dismiss, Whitehead was supposed to respond to that. The lawsuit, the foreclosure is against Whitehead and Whitehead Estates. So hopefully that's a quick, brief summary. Thank you so much. I see all the new members. Yes, everyone, I have opened up the membership. So I want you guys to come in and please become a member. I appreciate it. And make sure you hit that like on your way in. I want you to subscribe if you haven't done so already. Cupcake has been rocking with me since morning. She is trying to get mod of the year. Because she has been hanging with me. She's hanging with me, and I appreciate you. I really do. LaFrance, hey, Jai. Hey, Maria, Wanda, Nessa. Hey, Thais. Thank you for stopping by. Chef Don, I see you in the house. Thank you guys so much. Jalicia, thank you. Yes, I'm trying to keep you guys informed even when I'm super, super tired. But let's get into this, man. So, as I said, there was a motion to dismiss the case that was filed from the finance company, and you'll see them on the caption when I put the document up. We went over there on a previous video. So what we were waiting on is Bishop Whitehead's response to that motion. There was no response. So what ended up happening is today there was like a battle of the paperwork. So that's one of the things I was keeping my eye on today. Whitehead's attorney filed a request to extend the time to respond. Okay. So we're going to put that up right now. That was the first thing that was filed. Now, you guys remember the issues with the receivership, right? The last video that we had on Whitehead Estates, it was allegedly the receiver did a report and it was filed. So we went over the report. When you get a receivership, he was ordered to turn over keys and all these other documents, and there were some complaints that some of the stuff wasn't turned over, and that was in the first receivership report. So now this is the attorney for Whitehead request for an extension of time. So you see it was filed June 12th. The undersigned, on behalf of the defendant, Whitehead Estates LLC et al., hereby request an extension of time of 45 days up to including August 5th, 2023, in which to file his response to plaintiff's motion for summary judgment. This was dated March 28th. They filed this, meaning the plaintiff, who is FM Loans, filed this March 28th, 2023, and today there was a request for an extension of time. Defense counsel reached out to plaintiff's counsel regarding this request, and the plaintiff represented that the plaintiff objects to this request. This is the first of such requests. Good cause exists to grant this request after the deadline set forth in practice section 17-45. So they asked for some grace and mercy to get more time, even though this was filed in March, and the plaintiffs basically said no. They was like, no. So Jalecia asked, I'm confused. Is the finance company wanting to dismiss because he paid? No, they filed a motion for summary judgment. They're trying to they're saying he doesn't have any defenses. We went over that motion as well. They're saying that Whitehead or Whitehead Estates don't have defenses to stop this foreclosure. So they're asking the court to just grant them what they're asking for on their complaint. That's what they're asking for. And of course, Whitehead has time to respond. And instead of responding, it appears that his attorney filed a request to extend time to respond, even though this motion to dismiss was filed back in March, because we went over it like 2-3 months ago. That's probably why you don't remember it, Jalecia, because we went over it so long ago. They're just trying a motion to dismiss. They're not trying to dismiss it like, oh, we're just dismissing it because we settled the case. They're doing a motion for summary judgment, which is they believe that they have proven their case and that the case should be dismissed based on them proving their case, i.e. that there should be a foreclosure. Now, Whitehead does have the opportunity to respond. So one of the reasons why we never went back to this motion, because we were waiting on his response. But now we see the reason why there was no response is because his attorney is requesting to get an extension of time. Thank you so much, Harper, from becoming a member. I appreciate it. I know. Yes, thank you so much. Okay, so we got it so far. I don't want to lose anybody here because there's about four cases I think that we've been covering. That's why I didn't, when new cases come out, I haven't been covering them like that because we're trying to conclude the ones that we have, So there was a request for an extension. And Whitehead's attorney already acknowledged that the plaintiff was like, no, bruh, I don't want to extend this. And that was put in writing. So the plaintiff's objection to defendant's motion for the extension of time to file a response. So as you see right here, the plaintiffs put that in writing, that they had a problem with that. All right, y'all with me? Y'all with me? So we're going to read that, what the objection is from the plaintiff. The plaintiff respectfully objects to defendant's motion for an extension of time to respond or oppose plaintiff's motion for summary judgment. Plaintiff objects because defendant's motion fails to provide any basis or rationale that merits an extension of time be granted, and because defendant's motion is not timely and is simply a delay tactic. Defendants have had nearly 3 months to formulate an objection to plaintiff's summary judgment and/or engage in discovery. Defendant's request for more time is feigned. On March 28, 2023, plaintiff filed his motion for summary judgment, to which neither defendant filed a written objection in violation of Connecticut Practice Book Section 17-45B. Thereafter, on May 31st, 2023, and after more than the required 45 days in compliance with Connecticut Practice Book Section 17-45C, plaintiff reclaimed his motion for summary judgment to the short calendar because it never came up on the calendar. After failing to timely file a written objection to plaintiff's motion for summary judgment, and after nearly 75 days since plaintiff filed his motion for summary judgment, on Saturday, June 10, 2023, defendant's counsel finally contacted plaintiff's counsel for the first time. They underlined that and they got it in bold and italics, as you see, to request undersigned consent to an extension of time to object to plaintiff's motion for summary judgment. Plaintiff objected. On June 12, 2023, defendants filed their motion for the extension of time to respond to plaintiff's motion for summary judgment, and therein have requested an additional 45 days. In totality, in the last 75 days, defendants have taken no action whatsoever to respond or oppose plaintiff's motion for summary judgment, have not made a timely request for additional time to file a response or opposition, and have not now provided a basis or justification that would warrant additional time. Defendants have not set forth what actions were taken, if any exist, to prepare their objection, have only now asked for the court to provide them with more than double the standard time to respond. Any extension of time under the above circumstances would be prejudicial to plaintiff and given without merit. Moreover, delay is defendant's strategy in this case. Plaintiff recently filed a motion for contempt and sanctions, which we're going to go over, against the defendants for their continued failure to comply with the court's receivership order. Considering the circumstances set forth in plaintiff's motion for contempt and sanctions, defendant's motion for extension of time is simply a delay tactic without legitimate or good faith justification, so that defendants can keep control of the mortgage property even longer by flouting this court's order and the practice book deadlines at will. Wherefore, plaintiff respectfully objects to the defendant's motion for the extension of time and respectfully requests that the court deny their motion for the extension of time. I think that's pretty self-explanatory, right? Thank you, C. Wilson, for the membership. It's pretty self-explanatory. They wanted, Whitehead and them want an extension so that they can respond to this motion for summary judgment. Apparently, I guess they're saying they do have a defense, I would assume, since they're asking for an extension. And they're basically saying in response, the plaintiff is objecting, saying this is just a delay tactic. These are their words, not mine. These are just pleadings. Of course, they're just allegations on what each side says. Now, one of the things that was mentioned in this objection by the plaintiff was that they filed a motion to hold Whitehead and Whitehead Estates in contempt of court. We are about to read that motion, the contempt motion. And let's see. And there's also an affidavit that we're going to read as well. Thank you. You said, how did this sucker Mr. Clarion call? You know. Thank you so much for the super chat. I appreciate it. I appreciate you. You didn't have to do it, but I am so glad that you did. Hold on. All right, let me pull that up real quick. Hold on one second, guys. Let me fix something real quick. Sorry about that, guys. Had to handle some business real quick. Did you just say I'm so churchy? What? You know what? This is FM Home Loans LLC, their motion for contempt and sanctions. We are about to go through this line by line, precept by precept. Again, these are all just allegations. I'm sure that Whitehead will respond to these allegations. Plaintiff's motion for contempt and sanctions. We don't need to read the intro. So let's go to the statement of relevant facts as they have defined it. On March 30th, 2023, this court appointed Ian Lagowitz, the receiver, as receiver of the property. Therein, the court specifically directed the defendants and their managers, members, partners, employees, agents, and affiliates to deliver immediate possession of the property to the receiver. Further, the court, 1, expressly enjoined the defendants and any person acting in concert with them from interfering with the receiver's possession and operation of the property. 2, required the defendants to turn over the receiver all keys within 48 hours of the receivership order. And 3, turn over all leases, operating bank accounts, books, and records related to the property within 7 days of the receivership order. The receiver did not gain access to the property until on or about April 11, 2023. See the affidavit. We'll go over that in a second. Since the date the receiver was appointed to today, the receiver has made numerous efforts to contact the defendants, their agents, and the defendants' counsel to obtain access to the property, be provided with keys, rent rolls, pertinent court order records, accounts, etc. from defendants. And then that's in the affidavit we're going to read. However, and despite numerous written demands from the receiver, the defendants have either been entirely unresponsive or have outright refused to cooperate with the receiver and comply with the court's receivership order. Additionally, despite attorney Hyde Inga's appearance for both defendants in the above captioned action, Attorney Inga has repeatedly represented to the receiver that he only represents Whitehead Estates and does not represent Whitehead in his individual capacity. And therefore, Attorney Inga represented that he cannot assist in this endeavor. He was like, I can't help y'all, bro. That's pretty much what the attorney has said, according to this affidavit we're going to read. On or about May 24, 2023, a video conference was held where numerous representatives from the city of Hartford, including Judith Rothschild, the city of Hartford's director of blight remediation and housing code enforcement, the receiver, the receiver's agents, and plaintiff's counsel were all in attendance. It mentions the affidavit again. At that time, the various representatives from the city of Hartford requested the receiver facilitate a housing, building, and fire safety code inspection of the property, including an inspection of all common areas. Y'all with me? Y'all with me? All right. Read. See, I need me a reader. At that time, the various representatives from the city of Hartford requested the receiver facilitate a housing, building, and fire safety code inspection of the property, including an inspection of all common areas, the basement of each individual unit. These inspections were specifically requested to identify and facilitate the resolution of the outstanding life safety and municipal code violation that remained uncured at the property. The inspection was scheduled for May 30th, 2023 at 12 o'clock p.m., and the receiver posted the requisite notice to each tenant on or before Friday, May 26, 2023. According to this, on May 30th, 2023 at approximately 9 a.m., the receiver's agent arrived at the property to prepare for the noon inspection. Upon arrival, they were greeted by Whitehead, who indicated that he had received word from, quote, several tenants that an inspection was to be completed, and Whitehead was there to prevent that from happening. Thereafter, the receiver's agent called the receiver in order to allow the receiver to directly communicate with Whitehead. When on the phone with the receiver, Whitehead reaffirmed his position that he was at the property to prevent the inspection from moving forward, and also to entirely prevent the receiver, the receiver's agent, and the city of Hartford's officials from gaining entry to the building. Most egregiously, Whitehead threatened the receiver when he stated that if the receiver wished to gain access to the property, that the receiver would, quote, better come down here with a SWAT team or else. Did y'all hear that? Did you guys hear that? Better come down with a SWAT team or else. This is in this man's affidavit. The inspections were subsequently canceled. Thereafter, the receiver sent a written notice via email to Whitehead and attorney Hyde, confirming that Whitehead's actions that day constituted a refusal to comply and cooperate. This is what he said when they came up there. Y'all know what y'all know how it went when he came up here and asked to probably come on them premises.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call
look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
All right, let's go forward. On May 31st, 2023, another video conference between the numerous representatives from the city of Hartford, including Judith Rothschild, the receiver, the receiver's agent, and plaintiff's counsel was held. At that time, Ms. Rothschild advised all those in attendance that immediately after the aforementioned inspections were canceled, she requested a police officer from the city of Hartford to visit the property and communicate with Whitehead. According to Ms. Rothschild, representations upon arrival, the police officer observed Whitehead at the property and confirmed that he intended to prevent the receiver's entry to the property. Ms. Rothschild confirmed that she would be receiving a written summary of the interaction from the police officer, and she also believed that she would receive a copy of the body camera video from the police officer. Yep, hold on one second. Hold on one second, guys. Hold on. I'll be right back. 1 second. Sorry, guys. Told you Dev's not here. All right. Back on point. All right. Let me get back to the content here. You guys have time to reread? Okay. The argument. So they go over what the standard of contempt of court is. Trial courts have the inherent authority to impose sanctions against an attorney and his client for a course of bad conduct and to enforce the court's own rules and order. And that's Millbrook Owners Association versus Hamilton. One type of sanction is finding of contempt. Quote, any person or court officer misbehaving or disobeying any order of a judicial authority in the course of any judicial proceeding may be adjudicated in contempt and appropriately punished. Contempt may either be criminal or civil. And that's PB section 113A. The violation of any court order qualifies for criminal contempt sanctions. Wherefore, however, the dispute is between private litigants and the purpose for judicial intervention is remedial, then the contempt is civil, and any sanctions imposed by the judicial authority shall be coercive and non-punitive, including fines to ensure compliance and compensate and complainants for life. So really what contempt is, it's not supposed to be for punishment purposes. Contempt is supposed to do whatever the court feels like it needs to do in order to make you comply with the order, like to help you out a little bit. So if it means I got to charge you $200 a day so that it hits your pockets and make you want to comply, then that's what contempt is for. So it's not supposed to be to punish you for disobeying the order. It's to help you, give you a little push along so that you can obey that order. In addressing the motion for contempt, the court's analysis is twofold, and that's Catcher v. Stagg. First, the court must resolve the threshold question of whether the underlying order constitutes a court order that was sufficiently clear and unambiguous so as to support a judgment for contempt. Second, the court must then determine whether the violation was willful or excused by a good faith dispute or misunderstanding. You guys see that case law right there. Contempt is either civil or criminal in nature. See the case law. Criminal contempt is conduct that is directed against the dignity and authority of the court. With criminal contempt, the sanction is punitive in order to vindicate the authority of the court. So it's punitive for the criminal and it's non-punitive for the civil contempt. Consistent with this principle, punitive fines levied in criminal contempt are usually payable to the state. Here, by threatening the receiver, Whitehead has threatened an agent of the court and challenged this court's authority. Civil contempt is conduct directed against the rights of the opposing party. With civil contempt, the punishment is wholly remedial, serves only the purpose of the complainant and is not intended as a deterrent to offenses against the public. Sanctions for civil contempt may be either a fine or imprisonment. The fine may be remedial or it may be means of coercing compliance with the court's order and compensating the complainant for losses sustained. So what I've just said, what the contempt is typically for. Here, by refusing to comply with the receivership order, Whitehead is refusing to acknowledge plaintiff's right to secure the property from waste in this litigation. A finding of contempt is a question of fact, whereas here a motion for contempt is based on an alleged violation of an injunctive decree. The burden is on the party moving for contempt to prove by clear and convincing evidence that the adverse party violated the clear court order and that the adverse party's conduct was willful. In considering a motion for contempt, the credibility of witnesses, the finding of fact, and the drawing of inferences are all within the province of the trier of fact. Pursuant to CG3 sections 52 through 256BA, once a party is found to be in contempt, the court has the authority to award the moving party its attorney fees, whether to allow counsel fees, and in what amount costs for the exercise of judicial discretion. Here, as detailed below, plaintiff's motion for contempt and sanctions should be granted because 1, the receivership order is sufficiently clear and unambiguous, And 2, there's sufficient evidence from which the court can conclude the defendants willfully violated the order. The receivership's order is clear and ambiguous. So then they're going to go through how it's clear and all of that good stuff. You guys hanging on in there? We're almost finished with this document, and then we'll get to the affidavit. So the receivership's order is clear and unambiguous. On March 30th, 2023, this court appointed the receiver of the property. Therein, the court directed the defendants and their managers, members, partners, employees, agents, affiliates to deliver immediate possession of the property to the receiver. Further, the receivership order in pertinent part 1 expressly enjoined the defendants and any person acting in concert with them from interfering with the receiver's possession and operation of the property. Number 2, it required the defendants to turn over to the receiver all keys within 48 hours of the receivership order. And 3, required the defendants to turn over all leases, operating bank accounts, books, and records related to the property within 7 days of the receivership order. In other words, the receivership order required the defendants, their counsel, and their agents to completely cooperate with the receiver in the receiver's efforts to obtain possession and control of the property, maintain the property, and otherwise carry out the duties set forth in the receivership order. As a result, there is no dispute that the receivership order is clear and unambiguous. Defendants have willfully violated the receivership order. As detailed in Langowitz affidavit from the outset, the defendants have completely refused to comply with the receivership order. Specifically, the defendants have threatened the life and safety of the receiver and his agents, refused to communicate with the receiver and his agents, refused to provide access and possession of the property to the receiver and his agents, refused to provide the receiver and his agents with all keys, passcodes, similar items within 48 hours after issuance of the receivership order, refused to provide the receiver with all existing leases for the property, refused to provide the receiver with all operating bank accounts, books, and records related to the property within 7 days of issuance of the receivership order, refused to turn over to the receiver any all rents, income, revenue, profits, and security deposits relating to the management of the property, refused to provide the receiver with any EIN and W-9 information as it relates to the property, refused the receiver and City of Hartford officials entry into the property, conduct required inspections of the property, and generally not cooperated with the receiver, and has turned over no information to the receiver. As noted above, and perhaps that is more egregious, Whitehead threatened the receiver when he stated that if the receiver wished to gain access to the building, that the receiver, quote, better come down here with a SWAT team or else, end quote. As this court is aware, a receiver is an agent of the court. Therefore, not only are the defendants not complying with the clear and unambiguous court order and threatening the safety of an innocent party, the receiver, but the defendants are threatening an arm of the court. Therefore, based on all the above, along with all the evidence adduced at the remote hearing on plaintiff's motion for the appointment of the receiver that was held on March 28th, it is clear that defendants have willfully violated the receivership order. In conclusion, for the foregoing reason, plaintiff respectfully requests that the court grant its motion for contempt and sanctions and grant such other and further relief as the court deems just and proper, including but not limited to entry of non-suit or default, a monetary fine, plaintiff's reasonable attorney fees and costs associated with bringing this motion, and finding that defendants are in civil or criminal contempt of the receivership order entered. Y'all hit the like button. You got me working late at night. We had an all-day court session today. Please hit that like button. Oh, threatened. That's what's alleged. This is all alleged. That's what they allege. And we're going to read the affidavit that this person did under oath related to everything that we just read. Oh, we apparently they are trying to get the footage because they're gonna have to have a hearing, I would surmise. It's gonna be a contempt hearing. They don't just grant it. I'm sure he'll try to respond, defend himself against these allegations. Let's go on to the affidavit. So this is the affidavit of Ian Langowitz in support of the plaintiff's motion for contempt and sanctions. You guys see that? All right. Let me take myself up off the screen. Okay. Let's focus on this affidavit. So he gives this background that he's 18. He's the managing partner of Triggerlid, and I am the court-appointed receiver in this lawsuit. So the basis of knowledge. I make this affidavit based on my personal knowledge of the facts set forth herein and based upon the business records maintained by my company. In my capacity as receiver, I have personal knowledge of the facts and circumstances set forth herein. Defendants Whitehead Estates, LLC, and Lamar Whitehead, aka Lamar Whitehead, Mr. Whitehead, and together with Whitehead Estates defendants are defendants in this action. Whitehead Estates is the owner of the property located at 150, 180, the Earl Street. So here's the facts. On March 30th, 2023, this court appointed me as receiver for the property. As part of the receivership order, I was instructed to take immediate possession and control of the property, be provided with all keys to the property from owner and his agents within 48 hours issuance of the receivership order, and also be provided with all leases, operating bank accounts, books, and any other records related to the property within 7 days of issuance of the receivership order. My staff and I attempted on numerous occasions to speak with the defendants and their counsel to find an amicable time and place to take possession of the property. The defendants were not responsive to our requests and were therefore not cooperative. Despite Attorney Hyde Inga's appearance for both defendants in the above captioned action, Attorney Inga has repeatedly represented to me that he only represents Whitehead Estates and does not represent Whitehead in his individual capacity. As a result, Attorney Inga has led me to believe he cannot assist with complying with the receivership order as Whitehead Estates own the property. After nearly 2 weeks of attempting to communicate with the defendants and without the defendant's assistance or cooperation, my team finally gained access to the property on April 11, 2023. However, I still did not have the keys for secured areas, records, operating accounts, rent rolls, or other pertinent records from the defendants that relate to the property. After I obtained possession of the property, an initial walkthrough of the property was conducted. The property remains in disrepair, and the conditions have been set forth in detail in my first report filed on May 15, 2023. We went over that report. So if you guys are in the comments right now or watching, go back to that video and see what that report said, because we went over that as well. At about the time of my initial walkthrough, I learned that an individual named Samuel Karoma, who resides in, I got the unit, was the superintendent. I have asked Mr. Karoma to provide me with keys to the property and the individual units. However, he has not cooperated. Mr. Karoma continues not to cooperate despite being presented a copy of the receivership order. On or about May 24, 2023, a video conference was held where numerous representatives from the city of Hartford, including Judith Rothschild, the city of Hartford's director of blight remediation and housing code enforcement, plaintiff's counsel, myself, and my agent, Anthony Jordan, were in attendance. At that video conference, the various representatives from the city of Hartford requested I facilitate a housing, building, and fire safety code inspection of the property, including an inspection of all common areas, the basement, and each individual unit. It was my understanding that the inspections were requested to, in part, identify and facilitate the resolution of the outstanding life safety and municipal code violations that remain uncured on the property. I complied with the city of Hartford's request and scheduled the various inspections to be conducted on May 30th, 2023 at 12 p.m. I instructed the appropriate I instructed the appropriate and required written notice to be posted and provided to each tenant, which was done on or about May 24, 2023. A true and accurate copy of the notice provided by my agents to the tenant is attached hereto as Exhibit A. On May 30th, 2023, at approximately 9 a.m., my agents arrived at the property and informed me that defendant Laura Whitehead was at the property. Mr. Whitehead would not allow my agents to enter the property and communicated that he would refuse entry to any official from the city of Hartford in order to prevent any inspection from being completed. After receiving an alarming call from my agents, I attempted to call Mr. Whitehead directly, but he did not answer. After my agents were able to arrange a telephone conference, Mr. Whitehead was speaking very aggressively and reiterated that he was there to prevent the scheduled inspection from occurring. Additionally, Mr. Whitehead made threats to me and stated if I wanted to gain access to the property that I, quote, better come down here with SWAT team or else, end quote. Immediately after this call, I emailed plaintiff's counsel advising them of the sequence of events and requested that a police presence be on the property should the city of Hartford wish to proceed with the scheduled inspection. The city canceled the inspections later that morning. On May 30th, 2023, at 12:52 p.m., I wrote Mr. Whitehead an email and copied plaintiffs and defense counsel. Therein, I confirmed that Mr. Whitehead that he refused access to the property to accommodate the inspection scheduled by the city of Hartford. I enclosed a copy of receivership order for Mr. Whitehead's reference. A true and accurate copy of my email to Mr. Whitehead is attached here as Exhibit B. On May 31st, 2023, a second video conference between the numerous reps from the city of Hartford included Judith Rothschild, myself, my agent Anthony Jordan, and plaintiff's counsel was held. On this call, Ms. Rothschild advised all those in attendance that immediately after the aforementioned inspections were canceled, she requested a police officer from the city of Hartford to visit the property and communicate with Whitehead. I can't. According to Ms. Rothschild representations, upon arrival, the police observed Whitehead at the property and confirmed that he intended to prevent the receiver's entry to the property. A copy of the police report as provided by Ms. Rothschild is attached here too as Exhibit C. Ms. Rothschild confirmed that she would be receiving a written summary of the interaction from the police officer, and she also believed that she would receive a copy of the body camera video from that police officer. So that answers someone's questions who asked about the body cam. As of the date of this affidavit, the defendants and their agents or representatives have not cooperated with me and have only interfered, delayed, obstructed, and or otherwise counter to the receivership order. As of the date of this affidavit, the defendants still have not provided me with complete access to the property, all keys, passcodes, or similar items for the property or the individual units within the property, all existing leases for the property, all manners of operating bank accounts, books, and records related to the property, and all other records and information requested to carry out my duties as receiver as set forth in the receivership order. I do not believe the defendants have complied with the receivership order. So then they attached the emails. And there was an incident report that was filed. Let's see what the content of the incident report. So this is the narrative from the incident report. On May 30th, 2023, at approximately 1100 hours, while assigned to Unit 252, I was advised by Judith Rothschild, City of Hartford Director of Blight Remediation and Housing Code Enforcement. The city was conducting an inspection of the property. I was advised that the city would like representatives from the Hartford Police Department to assist and accompany inspectors as they conduct inspections through the common areas of the four buildings. The joint inspection was scheduled for 1200 hours on May 30th, 2023. At approximately 11:34 hours, I was advised by Rothschild that the City of Hartford's joint inspection was postponed due to the property's owner's refusal to allow access. I was asked for Rothschild if Officer Romero and I could respond to the property to conduct a follow-up with the property owner, Lamar Whitehead. Rothschild asked us to verify that Whitehead would not allow an inspection today and obtain a time frame of when the inspection would be conducted. Officer Romero and I responded to the residents 1,200 hours when we met with an individual who identified himself as the property owner. Officer Romero and I informed Whitehead that we were stopping by in an effort to establish a time frame in which the city of Hartford could conduct an inspection of the property. Whitehead stated he was unaware of the inspection schedule for today. Whitehead stated he was not contacted by a representative from the city of Hartford. Whitehead further reported that he learned of a planned inspection from his building superintendent. Whitehead reported that the tenants were upset over a letter they received from the management company. Whitehead reported that the letter informed the tenants of a planned inspection for the day, which stated that entry would be made into the units whether they were home or not. Whitehead further reported that the letter informed the tenants that their locks would be changed and key would be left for them. Whitehead stated that he came by the apartment complex today to ensure that the tenants' locks were not changed and that no one would go inside tenants' occupied apartments without permission. Whitehead reported that he would allow access to this building, but wanted to be present at the time of the inspection. Whitehead reported that he would next be available around the first or second week of July. Whitehead stated to have a director of housing, Judith Rothschild, reach out to him directly to arrange a time. It should be noted that my department issued body-worn camera was activated during this interaction. I did not view the footage prior to the writing of this report. Incident documented for documentary purposes only at this time. So that is the incident report that was filed or filled out. So that is what is going on at Whitehead Estates. So let me see what let me let you guys see what we're
in the rain, y'all. Slowing down the rain, but we working. We are working, y'all. Working. Stairs complete. Whitehead Estates, y'all. Coming all together.
That is Whitehead Estates. We have went over all the documents from what's going on at Whitehead Estates right now. So apparently he would like them to come in and inspect the property in July when his next available date is. You know what? You know what? Oh man, let me see it. Let me see what comments I got. I know you guys were chit-chatting in these here comments. Let me say, get the video. I don't know why YouTube does me like that. I don't know why they're not sending out notifications, but usually I get more notifications for these type of stories for some reason. It's hit or miss. I don't know. I have several people that tell me they don't get the notification. They just happen to come across my page, see that I went live, a few hours before. So I don't even know how to remedy that. I wish I did. Okay. I'm trying to see if you guys got any comments. He said they his estates, man. Let them be great. He said, let me be great. He said his name is iconic. I mean, he has all type of estates named after him now. So I mean, somebody said, but he got time sitting in the car live arguing with everybody. Child, if he looking at this court order, according to them, they saying he thumbing his nose at this court order. What you think he gonna do about us old regular people? He ain't thinking about us. If this is true and accurate. But right now it's just alleged until they have a court hearing and we see what the court determines. He said he thought this was New York, but no, these Connecticut got time, don't they? Connecticut been his attorney filed motions back to back. Like his attorney filed, it was Saturday, but they didn't post it till like Monday, till today. So he filed trying to extend the time. Then he tried to withdraw it, I believe. Then he refiled trying to extend the time. The attorneys for the loan company responded, objecting to him trying to extend the time, and then filed a whole motion for contempt on top of it. Oh, they paperworking each other. That plaintiff, oh, they paperworking. They not wasting no. They are not passing go or collecting $200. As soon as something is filed, they are responding. This is civil litigation at its best. So I don't know. Where do we go from here, guys? Intellects, what do you think happens now? I mean, they're going to have a hearing, of course. He has the right to defend himself from these allegations. But what do you think happens now? Is the judge less like to accept an extension because he didn't know how to enter the building? I don't know if those really. I think if the judge does not allow the extension, it's because it was at the 11th hour. Like he didn't really give in a reason. He just said, I have good cause. Usually somebody says things like, I had a death in my family, I was sick, I was in the hospital. You know, you have things that do happen that may affect you. The issue with this is they filed their motion on the same day that hearing was that we talked about, the last hearing that they had for the receivership, and we had the transcript to it and all that. They filed their motion for summary judgment on that day. So you're saying since March, you pretty much knew this existed, or your attorney pretty much knew this existed. So that's a long time to then say, you know, like 2 days before you're supposed to have either a response or hearing. I don't know what was due. I'm assuming maybe the response may have been due. And then you like, hey, time's out. Can I get a couple of, 45 more days? Revival Concept says they believe that he is in contempt of court. They need to just stop giving him extensions. Then I think like on his criminal case, he had a hearing. I think it was set for tomorrow, but that just got extended to July because his attorney had a conflict. So that just got extended for another month. Thank you so much, Lisa, for the Cash App. I appreciate you. Y'all got any questions to me? Because, I have an early 9:15 trial to get to in the morning. And I want to make sure you guys are there with me, too, because we had a good time going over that trial. You said Trump must be the mentor. So we're going to follow this case, guys. We're going to follow it till the end. It seems like it's never ending, too. But again, he is still the owner of the property. The building has not been foreclosed on. What the plaintiff is trying to do is file a motion for summary judgment, which would, and they're asking the court to just grant what they're asked for in the complaint, because they're saying there really were no defenses that he can wage to stop him from foreclosing on the property. So that's what he needs to respond to. That has not been responded to, and what they're asking for an extension on. The receiver situation has already been litigated. Like, there was already a hearing, cross-examinations. Remember when I was telling you they brought up his past and all of that? There was already a hearing on that. So on that hearing, the court entered that order that we went through, where they entered that order allowing a receiver to come in. And there were certain things and time frames that we just went through on those documents of what he had to do to allow the receiver to do their job. And according to them, they haven't been allowed to do their job. So
You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
I don't know what else to say, guys. What else do you want from me? I'm just delivering the legal news. That's it. So there we have it. We have our update on Whitehead Estates. Thank you guys for rocking with me. It's 11 o'clock. You guys can be anywhere over on YouTube, but I'm glad that you're here with me. Again, I have membership. Go become a member and like my video, and make sure you subscribe if you haven't done so already. And I need you to join me in the morning for this trial if you got time, because it is long. So I was trying to do work. I got a couple of things I have to do tomorrow for the court, so I might have to jump off, but I'm gonna still have it rolling and streaming at the same time. But just come in every now and then. We have good dialogue. We get to see a trial, why it is occurring. And yeah, we've had a good time. Thank you, Revival Concept, for the super chat. I appreciate it. So I'm gonna, hit my good intro since I don't have an outro yet. We waiting on that. We need my son to move a little bit more speedily, but he does work 2 jobs. So gonna give him a pass. But I've been trying to wait for my outro. But anyway, guys, I'll see you guys early in the morning. So I'm going to let you guys leave out on my little bop.
Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest. Not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.